Everybody ready? Good evening. We are calling this meeting of the September 12th, 2024 Rent Control Board meeting opening. Can I please have a roll call?
Yes, Commissioner Ivanov,
Here.
Commissioner Ambrose,
Here.
Commissioner Foster,
Here.
Vice Chair Gonska,
Here.
Chair Leslie.
Here. Will we please have the Pledge of Allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Everybody reviewing the minutes for a couple of minutes? Let me know when you're ready.
I move we approve the minutes.
Second.
Second.
We have a roll call vote, please.
Yes, Commissioner Ambrose,
Yes.
Commissioner Foster,
Yes.
Commissioner Ivanov,
Yes.
Vice Chair Gonska,
Yes.
Chair Leslie.
Yes.
Motion carries.
Now, do we have any special agenda items?
Thank you, Chair, and good evening, Chair, Vice Chair, Commissioners, and members of the public who are joining us tonight. As I mentioned at your last regular meeting, the general adjustment took effect on September 1st. As a reminder, the general adjustment as of the 1st is 3% with a ceiling of $76, meaning that a maximum increase of $76 would apply to all units with current MARs of $2,517 and above. If any landlord or tenant has any questions about implementing the MAR, they should contact staff at 310-458-8751. Santa Monica is developing a citywide action plan to enhance services for older adults, people with disabilities, and caregivers. The city is building the plan in partnership with the Santa Monica community, thanks to a California Department of Aging Local Aging and Disability Action Planning Grant, and with support from the AARP Network of Age-Friendly States and Communities. As part of these efforts, the city is seeking to create an advisory committee that reflects the diversity of our community. The city is recruiting community stakeholders to be committee members, including older adults, people with disabilities, caregivers, and current and retired industry professionals. People who represent related fields are also encouraged to apply, including public policy, health and social services, financial services, philanthropy, nonprofit management, and diversity, equity, and inclusion. For those who are interested in serving on the advisory committee, a statement of interest is due by noon on Monday, October 7th. Information on how to apply can be found by going to santamonica.gov and typing Aging and Disability Action Plan into the search bar, or by calling 310-458-2200, extension 5771, or by emailing humanservices@santamonica.gov. Applications are available in English, Spanish, Russian, Farsi, and Amharic. That concludes my remarks. Thank you, Chair.
Thank you. Now, do we have any public requests to speak? Okay, thank you. Okay, we're moving on to item 10A. Can I please have a staff report?
Good evening, Commissioners. This is for the property at 1851 Euclid Street. The owner, Kofax Euclid, constructed 2 new units on the property, units 1853A and B, and they're seeking a permanent exemption from the rent control law. The rent control law provides a permanent exemption for newly constructed units if they were constructed after the enactment of the rent control law and are not otherwise subject to the law as a result of the Ellis Act or a removal permit. Here, these 2 units received their first certificate of occupancy in April of 2024, and the property was neither withdrawn under the Ellis Act nor subject to a removal permit. Therefore, there's no basis to subject these units to the rent control law, and they qualify as exempt new construction. And for that reason, staff is recommending that the board grant this exemption application and adopt the proposed findings of fact and conclusions of law.
Chair Foster.
Thank you. Because these two are identical, items 10A1 and 10A2, with no significant differences whatsoever except for the number of units, the subsequent report only being 1 unit, I move that we approve item 10A1 and 10A2 taken together, if there's no objection.
I would second that.
May we have a roll call vote?
Yes, Commissioner Foster,
Yes.
Commissioner Ivanov,
Yes.
Commissioner Ambrose,
Yes.
Vice Chair Gonska,
Yes.
Chair Leslie,
Yes.
motion carries.
Thank you. Now moving on to item 10A3. May we please have?
The property at 25 25th Street is a single-family home, and the McCulloughs own this property, and they have applied to permanently exempt it from the rent control law as a single-family home under Charter Section 1815. And to qualify, they need to prove that they have lived on the property for at least 2 years as their principal residence. They don't own any other property in Los Angeles County, and they submitted utility, financial, and government records that confirm that they do live there for at least 2 consecutive years. And for those reasons, staff recommends the board grant the exemption application and adopt the proposed findings of fact and conclusions of law.
Commissioner Ambrose.
Just a quick question. In other cases, when we've asked, when a person asked for an exemption and it's an apartment building, we've taken into account evidence such as, like here, driver's license, there's water, gas, and bank records. But in other cases, we have sent out questionnaires for other tenants in the building. Here, this is a single-family home, and I'm wondering if it's ever possible to send out the same type of questionnaire to residents in the neighboring area.
Well, in the other exemptions, we don't, the only response reports we send are to tenants on those properties. For the 2 or 3 unit properties, we send it to them, and then we collect the information, and I call and follow up with those people. Since this is a single family home, we do send the mail to the home to make sure that anybody who's there is made aware of the fact that this exemption application is going forward. Same thing with the staff report. And so that's why it's different in this case, because it's just a single family home versus the other ones.
Okay, thank you. In that case, I'd like to make a motion to approve item, staff recommendation to permanently exempt this property from the rent control law as a single-family home. Thanks.
Second.
May we have a roll call vote, please?
Yes, Commissioner Ambrose,
Yes.
Commissioner Foster,
Yes.
Commissioner Ivanov,
Yes.
Vice Chair Gonska,
Yes.
Chair Leslie,
Yes.
motion carries.
Thank you. Now moving on to item 10B1. May I please have a staff report, please?
Certainly. Commissioners, this is an appeal of a decision that granted rent decreases to tenants from 4 units on this property where the owner has been constructing multiple ADUs. The hearing officer granted rent decreases for construction impacts that either substantially reduced housing services or substantially interfered with the tenant's ability to occupy their units as a residence. The board's regulation authorizes rent decreases for construction impacts that result in either. The property owner, 1138 Princeton LLC, has appealed that decision based on various arguments that have been addressed in detail in the staff report and supplemental staff report. I'll briefly summarize. The landlord argues that no decreases should have been granted because code enforcement never found any of these units uninhabitable, but none of the decreases granted by the hearing officer were based on a finding that a unit had become uninhabitable. The landlord argues that the percentage decreases granted for various impacts or the period of the decreases are not based on the evidence as detailed in the staff report. However, substantial evidence supports the decreases granted in this case, including as to amount and period of the decrease. The landlord argues that the decreases granted for loss of the parking amenity to the tenant of Unit 1136B is an error because the landlord had the tenants lease their garage space from a third-party leasing entity. The hearing officer, however, found that the tenants were entitled to a decrease for losing this amenity because they were paying for parking for a garage space owned by the property owner on the owner's property, and the property owner has eliminated those amenities to build additional units. Substantial evidence supports that finding. The landlord objects to the fact that the hearing officer determined the correct MAR for a couple of units where the evidence showed that the amount that the landlord had registered as the initial MAR was incorrect. The fact is that the board's regulations require the hearing officer to determine the correct MAR as a threshold issue in a rent decrease petition, and the hearing officer's MAR determinations are supported by substantial evidence and are in accordance with board regulations. The landlord argues that the hearing officer abused her discretion in consolidating the petitions, but the hearing officer did so in accordance with the requirements of the board's regulation for construction decrease petitions, and the landlord never objected to that consolidation. The landlord also argues that granting decreases for impacts from construction of ADUs violates the restrictions in the state ADUs laws on local jurisdictions, but the argument is without merit. The board's construction decrease regulations do not govern a landlord's ability to construct ADUs. They provide for an adjustment of the rent when the owner's construction results in any of the grounds for a construction decrease under the board's regulations, regardless of the type of construction. Nothing in the state ADU laws preclude the board from doing so. Because the hearing officer's decision is supported by substantial evidence and is in accordance with the board's regulations, staff recommends the board affirm the decision and its findings of fact and conclusions of law.
Thank you. So I have a request to address the Rent Control Board from Ada Cordero Sachs. Could you please step forward?
Good evening.
Good evening.
May I
You have 5 minutes.
Okay. Sometimes what's interesting is what's not discussed as opposed to what is. There are two items that we addressed in our memorandum that aren't addressed in the reply memorandum, and that's the 120-day threshold. Your rent control law clearly says at 1805D12 that all rent petitions will be adjudicated within 120 days, and these were a year over the 120 days. The regulations also back up that the decisions shall be decided and adjudicated within 120 days. So both the rent control law and the regulations have this 120-day threshold, which here was clearly exceeded. So we submit that, of course, the board has its authority through the charter, and since it exceeded its authority in the charter, we submit that that's a abuse of discretion because the hearing officer did not follow the law, and that's the definition of abuse of discretion. So that's one issue. Second issue is we talk about the hearing officer doing her own research. Your rent control law, as well as your regulations, clearly say that your hearing examiner has to be like a judge, impartial. But when somebody conducts their own research, they are showing that they're biased and that they're partial. And then from conducting their own research, they came to an incorrect factual conclusion. So we submit that wasn't addressed in any of the memoranda. And I have 4 quick points to go over. We submit that an example, there's a fire marshal example that we use, and it's not because the hearing officer did or did not use that to make an adjudication. The point of the fire marshal example is the hearing officer weighs evidence disparately. When the tenant makes a declaration, it's unrefuted, and it was unrefuted. But when the landlord makes a declaration that's unrefuted, they need to have substantial and corroborative evidence. So we submit that it's an unfair hearing when you have a different evidentiary standard for the litigants. The next issue is sanctions. I'm not sure why in your memorandum it says that the sanctions portion was redacted. It's part of a public record, which is 24 STCP 02381. But in any event, the issue with the sanctions is your charter clearly says that any litigant, a tenant or a landlord, may petition the court for their grievances. And of course, that's in 1805 D18, then it's also in section 1808. So the fact that the landlord's representative was threatened not once but twice with sanctions just for going to the court, we submit shows that it's impartial and it's not a fair hearing. The last two things we added was some testimony from Woodnicki. She's one of the investigators that the hearing examiners use. The purpose of adding that was that we learned in that hearing, we've done a lot of these, that there's a secret memo out there that the hearing examiner gives the investigator that's not part of the administrative record. We submit that shows it's an unfair hearing. And the last thing is, this was discussed in their memoranda, but we talk about there being a Zoom meeting. There was never an option to have a public hearing like Here We Come. And I know that they submit that there is that option, but that it was a fait accompli. When we received the notices, it's a Zoom meeting, here's your login. So those are the 6 things I wanted to touch on, and of course, all my arguments are in my memorandum. Thank you.
I have a question.
One second.
Sorry, I just have a question. Thanks. So page 10 of your brief, section D, hearing the heading being hearing examiner must be impartial, semicolon, render decision within 120 days. So I'm not understanding the argument why the decision being late equates to the hearing examiner then inherently being biased or impartial towards, or not impartial towards one party or the other. I think you just touched on the fact that your basis for why the hearing officer was biased was because she did her own research. I didn't see that as an argument here in section D in terms of impartiality. So can you just clarify a little more, like what research specifically are you talking about that renders you to think that the hearing officer was somehow biased here?
Well, the 120-day thing, just to touch on that, that's in your charter. So that's just, she just violated the charter, so that's an abuse of discretion when you violate the law. So in terms of impartiality, there's several examples of impartiality in unfair trial, like the fire marshal, but in particular, the part about doing her own research, a judge doesn't do their own research. A judge is not allowed to do their own research. That's what the litigants are for. And she could have clearly said, hey, give me this information to either side. But she took it upon herself to take administrative notice and then comes to the incorrect conclusion that the owner and the garage folks are the same. No, they're not. They're different entities. And she comes to this conclusion, and this is on page 43 of her Exhibit A, of her 113-page memorandum or decision, is I'm the agent for process of service on a ton of entities. So what? Doesn't mean that they're related. So to answer your question, I submit that it's impartial to do research on your own as a hearing officer, as a hearing examiner. That's what I submit, just like a judge.
Okay, and so part of your argument is also that the decision being late itself inherently means that the hearing officer was biased?
I'm not sure why those were together. My memo is 22 pages, so I can, if you want to show me the page, but the part about the 120-day, it's substantial prejudice to the landlord. And I'm going to even argue for the tenant as well, because they have to wait a year to do anything, to refinance, to do what they're going to do. And it's in your charter. So when you violate your own law, which is it shall render a decision in 120 days, that's my submission. Now, the part about unbiased, I just think she violated the charter there. Okay. The 120 days. I have other examples, so I apologize if it was a little, you don't have a lot of time to do these. So I apologize, a little mixed up, but.
No worries, thank you.
Thank you.
Excuse me.
Sorry.
Commissioner Foster.
Thank you. Did you or your client petition for writ of ordinary mandamus?
We did.
All right. I'm informed by the staff report that you did not.
We did. That's the case number I just gave you.
Oh, that's the case number?
Yeah.
Okay, so the original
And that's
staff
when we were
report.
threatened with the sanctions for,
Right, but since that case is not resolved yet,
you know.
we are not, it's not a part of this record. So we're dealing with an appeal on this case.
Right, but before, we appealed this case, and as this appeal was pending, we asked for a stipulation.
But that's a separate, would you agree that's a separate proceeding?
No, it's not a separate proceeding. It's all the same thing. I
thank
hear you. I mean, if you.
Thank you.
Yeah, okay, thank you. Anything else?
Yes. Does any other commissioner have any questions? Okay, so I have a few. So on page 5, so I have a couple of questions. So as far as you saying the approximate expenses per month on the two buildings are, the utilities are $1,200 a month? Not the unit, I'm sorry?
Yes, these are you're talking about page 5?
Yes, I'm talking about page 5. I'm sorry, in the brief, the addendum that she submitted.
Yeah, page 5 in her brief.
Yeah, so you're saying the utilities are $1,200 a month?
My understanding is the tenants pay their own utilities.
That's what I was about to ask. So even with the tenants paying their own utilities, it's still $1,200 a month?
That's my understanding. This is from a declaration from the landlord's representative, yes.
Okay. And there's repairs every month on all of the units?
Yes.
Chair Leslie,
Yes.
this might have escaped. This was not part of the record below. We decided to leave it in the staff report because it was part of her argument. But you'll note in the supplemental staff report that was given to you all, we noted that these expenses that are laid out in her supplemental response were not presented to the hearing officer. They're not part of the
Okay.
record. Yeah.
Okay.
You have a chicken egg problem. You wouldn't
no-
present them at the administration.
So there are rules and regulations. Whatever you present is what we can discuss here on this dais. If it wasn't presented prior to, or even a part of this case, we can no longer discuss this.
Including the 120-day, there's no way to know you're going to be outside the 120 days till the decision's issued.
Allison, please turn on your mic.
I'm sorry, there's a fly that's.
So this is a separate issue. We're talking about facts that were not presented to the hearing officer. An argument about the charter is obviously a legal argument. These expenses were not presented, and that's what can't be considered by the board. Thank you.
Thank you.
Thank you so much. Anything else?
Thank you. No. Anyone else? Hold on. Anyone else have any questions? Okay. Thank you.
Here, everybody. Thank you so much.
Okay. So we'll take this into discussion. Commissioner Foster.
Thank you. Not hearing any other commissioners making discussion, I am not persuaded that there was error in the procedures or the findings of our hearing officer. And because the officer's finding and decision are supported by substantial evidence and are in accordance with our regulations, I move that we affirm the hearing officer's decision and findings of fact and conclusions of law.
Hold on. Commissioner Ivanov.
Yeah, I just want to ask one question for the staff. Can we just get a little more clarity from the, on the 120-day issue? I know it was addressed in the supplemental staff report. I just want to kind of understand that argument a little better in terms of, I know the hearing officer still has discretion if the decision needs to be later than 120 days, and obviously it's a very voluminous record. Is that the basis for why the hearing officer has discretion to disregard the deadline?
Yes, and the case law is cited in the staff report, so it's on page.
It's in section D, letter D.
Yeah, the initial staff report addresses it, section D, page 12. So Santa Monica Properties versus Santa Monica Rent Control Board is cited there, as is Board of Education versus Sacramento City Board of Education. So not surprisingly, the courts understand that the burden on administrative processes can sometimes be very great. And so that's why it's not a fine black and white line when it comes to these types of timelines.
Excellent, thank you.
Just have a quick follow-up question on that specific point, if I may. Is this, obviously there's a lot of facts in this case, a lot to sort through. Is this out for any other cases that may have occurred in recent years that were this complicated or this many pieces of information to go through? Would it be unusual for it to take this period of time that this case took?
No, this is not unusual at all.
Okay, thank you.
Commissioner Ambrose.
I think that staff did an excellent job in preparing this this memo and the staff report for us. It was very lengthy and but also very digestible and very interesting to read. I think that the issue that that we're being presented with is simply we're being asked whether the landlord or the owner here should have the decrease, or the appeal is for the rent decrease. And here the hearing officer had it was within their discretion to in different for different issues to award a certain amount of decreases. And from the record, there were a certain amount between 10 and 50%. And I thought that the hearing officer was very fair in determining, sometimes very middle of the road. There could have been up to 50% or a maximum amount. And I thought that the evidence was very clear. Some of the legal arguments I thought were without merit. And I think that the amounts for the decrease were fair. And for that reason, I think that we should pass this and find a motion for this.
There's a motion on the floor.
Okay. Then I second them.
Commissioner Gonska has some questions.
Okay. Well, then I second it unless,
No,
okay.
yeah.
Okay. So on the issue of the parking, and I know there's some disagreement between the parties about the entity that owns or controls the parking, but my question is about, my understanding from the staff report is that the $150 for the parking was added to the MAR, is that correct? So here what we're dealing with is because it was added to the MAR and that amenity no longer existed, it needed to be removed from the MAR, otherwise the landlord would have the legal authority to charge that $150 without providing the amenity, correct? Okay, thank you. And then my only other question is about the matter of the Zoom hearing. I understand that the procedures allow for the either party to request an in-person hearing that isn't necessarily public, but is in person versus online. Can either party also object and try to change the format of the hearing once it's begun? Like if they were doing an online Zoom hearing, could they ask for it?
Yes, and it happened rather recently. I know that because where I was sitting, and somebody requested a translator, and for that reason, they had to reschedule it, and it has to become a live. By live, I mean to say an in-person thing, because that works best with translators. So there certainly is an opportunity for people to object and to request an in-person thing, even after it's already started.
And in this hearing before us, did either party request for a change during the hearing?
No.
Okay. And so it was only brought up as a complaint in the appeal, is that correct? Okay, thank you. That's my only question.
Okay. So there's a motion on the floor. I will second that motion. And can we now have a roll call vote?
Yes, Commissioner Foster,
Yes.
Commissioner Ivanov,
Yes.
Commissioner Ambrose,
Yes.
Vice Chair Gonska,
Yes.
Chair Leslie.
Yes.
Motion carries.
Thank you. So now we are moving forward to adjournment. And I'd like to adjourn this month's meeting in honor of Latino Heritage Month. So thank you, and our next meeting will be October 10th, 2024 at 7 o'clock. Thank you. Have a good night.